Friends, let's see some legal maxims in our journey of legal language. Now, legal maxims, what are legal maxims? Legal maxims are said to be the pillars on which the legal system stands. These maxims find a place in the jurisprudence and law of every civilized country. The maxims are usually expressed in Latin, and reference is often made to them as first principles. I am going to discuss some of them in this and the next episode. Let's start. 1. Ubi jus ibi remedium. Now, what does this mean? This means there is no wrong without remedy. Now, jus means legal right to do something, and remedium means the right action in the court of law. Thus, the maxim lays down that whenever there is a legal right, there is also a legal remedy existing. It means that every legal right is supported by some legal remedy if something goes wrong. Only thing to be remembered here is the damage suffered should be legal damage, which is called injuria, otherwise no suit will lie. There are many political and moral wrongs which are not recognized by law, so they are not actionable. So there has to be a legal injury for you to get a legal remedy for it. That is what it's meant by ubi jus ibi remedium. Second is damnum sine injuria oblique injuria sine damnum. Now, what does this mean? It means actual damage suffered without legal injury and legal injury suffered without actual damage. Damnum means loss or damage or harm, or injuria means legal injury. So in this case, a Gloucester grammar school case says, wherein a rival school set up lost a school at competitive prices. So there was a loss of business to the earlier school which was running, but there was no legal injury, and hence there could not be any legal remedy lying. Conversely, Ashby versus White is a classic case study, landmark judgment. He was not allowed to cast a vote by the electoring officer. So, although there was no damage to Mr. Ashby as such, a legal injury took place and he had a remedy to it. Third, volenti not fit injuria. It means damage suffered by consent is not a case of action. For example, if you give consent to a motor race participation, and if there is an injury because of your own fault, then no action can lie because you have consented to the taking part into the motor race. Fourth is de minimis non curate lex, which means law does not concern itself about trifles. Example, a touch or a brush against the body of another gentleman standing nearby in a crowded local train cannot call for a legal action because it is a trifle thing. Now, fifth, res ipsa loquitur means the thing speaks for itself. For example, it is said that the killer leaves some proof or other of his crime at the site. So, for example, if hammer falls out of the window, there could be a case of accident, negligence or mischief. But if a table or chair falls from the window, then it's definitely not the accident. So the thing speaks for itself. Now next is 6. Rex non protest picare means the king can do no wrong. Now the example is the government is not liable for any wrong done by its servants in the course of their official duty unless the wrong was expressly authorized or ratified by the government. So it is expected that government doesn't do any wrong thing. Now next is respondent superior, which means let the superior be responsible. This is called a vicarious liability. Thus, a master is liable for the wrongful act of his servants. Now next is actus non facit reum nisi menstria, that is the intent and act must both concur to constitute the crime. This we have seen in the last episode, that the intention and action must be present for the, and injury also must be present to take a crime. Next is ninth, audi alteram partem, means no man shall be condemned unheard. For example, always opportunity is given to the defendant to explain his side, and no action taken on him otherwise only on the basis of the plaintiff's case. A landmark case of Mrs. Maneka Gandhi passport cancellation without giving a hearing to her by state was set aside by the court. Now next is nemo debet is a judex in propria causa, which means no man can be judge in his own cause. This is a fundamental rule of natural justice, that a person cannot be a judge in the cause in which he is interested. The judge should be impartial and neutral and free from bias. For example, in a landmark case of Dr. Bonham's case, a doctor in Cambridge University was found to be practicing in London without a license from college. So he could not form a member of the investigating committee to award the penalty. Next is nemo dat quod non habet, means no one can give what he does not possess. We have seen this in episodes in will, that a person cannot will out property which he doesn't own or which is not his. So no one can give what he does not possess. Now next is caveat emptor, which means let the buyer be aware. The buyer must take care while buying specific things. Thus, except in case of fraud, the purchaser buys goods at his own risk unless the seller gives an guarantee or warranty. Next is actus dei nemini facit injuriam, which means that the law holds no man responsible for act of God. For example, death due to lightning, landslide, earthquake, etc. Nobody can be held responsible unless some element of negligence, etc. can be proved. Next is nemo tenor sepism accura, which means no man can be compelled to incriminate himself. For example, a rule of evidence that a confession by an accused to police officer doesn't stand in court of law unless it is proved that such confession was free and voluntary. So, nemo tenetur seipsum accusare is what it means. Now next is salus populi est suprema lex, which means regard to public welfare is the highest law and applies in the cases. For example, some land acquisition or acquirement by government to build a highway in the interest of the public welfare. The owner may be compensated adequately to shell out the land, but government has right to acquire it. Next is code ab initio non valet intraction tempori non convalescent sit, means that which was originally void does not by lapse of time become valid. Excuse me for my pronunciation of the Latin words. Now the example of this is a contract signed by a minor under the age of 18 years is void as per the law. It does not become valid after the minor attains the majority. So we stop here at the moment, and in next episode we will discuss some more legal maxims. Thank you.